first, I need to work with my great office assistant. We have some minutes drafted. Want to take a look at those. It was from our hearing on 2303. Would entertain a motion to accept the minutes. Representative Brantley.
Thank you, Mr. Chair. I move that we accept the minutes.
Got a second from Representative Johnson. Do we have enough? Elsie, you want to vote? You want to vote with us? All right, this is for approval of the minutes. All in favor, say aye. Aye. All opposed? Minutes are adopted. Thank you, Rose, for your hard work on that. Next up, we are going to bring Nick Myers up to do a presentation from the Reviser of Statutes.
Okay, thank you, Mr. Chairman. Mr. Chairman and members of the committee, first off, good afternoon. I have two documents in front of you, two memos from the Office of Reviser of Statutes. And I'm going to start with the bigger one. It is just an overview of special education law. It covers the IDEA, the Individuals with Disabilities Education Act, and then the Kansas Special Education for Exceptional Children Act. And just, I'm not going to go through the whole memo. This is just kind of the why. Why is special education required, and just why kind of set us up for our funding discussion that we'll have here soon. As you all know, the Individuals with Disabilities Education Act, I'm going to refer to it as the IDEA, requires that all children, including children who have disabilities, have a right to a free, appropriate public education. And school districts are required by the federal law and by state law to provide this free, appropriate public education to meet the academic needs of children with disabilities. So the IDEA, and I'm just going to cover a few things in here. The IDEA requires that special education services be provided to children with disabilities from birth through age 21. And the law prescribes requirements for the provision of the special education and related services by the state and school districts, otherwise known as local educational agencies. So this is the primary federal law that governs the provision of special education and related services. I will note also that there are a couple other federal laws, specifically Section 504 of the Rehabilitation Act, and then the Americans with Disabilities Act, otherwise known as the ADA, both also play a role as they prohibit discrimination based on a disability. So again, I'm going to skip through a few of this, like I said, a few sections of this. So again, IDEA places the responsibility to ensure that FAPE, the Free Appropriate Public Education, on state and local educational agencies. And what this generally requires is that FAPE be provided to children with disabilities in the least restrictive environment, otherwise known as the LRE. The law requires school districts to identify and evaluate students who have disabilities at no cost to families. This is otherwise known as the child find requirement. It requires schools to offer special education and related services to meet those needs of children with disabilities through what is known as an individualized education program, or an IEP. And then also it defines the rights of children and parents with regard to the provision of special education. So there's multiple requirements within IDEA. First off, there's a full educational opportunity goal for children with disabilities. There's child find requirements. This is the requirement that school districts identify, locate, and evaluate all children who may have disabilities, even if they're not attending the school, a school of the school district. If they're just simply being located and residing within the school district, that child find requirement still applies. And to locate and evaluate students with disabilities. Once a student is identified as possibly having a disability, the law kicks in to state that the school district has a requirement to seek permission from parents to conduct an initial evaluation of the child. And then also, even if the school district doesn't request that, a parent may request that initial evaluation be conducted based on knowledge that the parent has of their child possibly having a disability and needing special education services. So this evaluation process, the school district, again, is required to conduct an initial evaluation to determine whether the child is a child with a disability and the educational needs of that child. So to qualify, this is one of the keys here, to qualify as a child with a disability, the child has to meet two requirements. First, that child has to have a specific exceptionality that's outlined in the law, and as a result of that exceptionality or disability, the child has a need for special education and related services to access and make progress in the general education curriculum. And in my memo and also in the law, you can see what the federal law, the categories of disabilities that the federal law outlines. So these are autism, deafblindness, deafness, developmental delays for children 9 years old and younger, emotional disabilities, hearing impairment, intellectual disability, learning disability, multiple disabilities, orthopedic impairments, other health impairments, speech or language impairment, traumatic brain injury, and visual impairment, including blindness. So this is the federal definition for under IDEA. So the evaluation would occur through using a variety of assessment tools and strategies to gather the functional, developmental, academic information for the child. And then there's other requirements with regard to maintaining and staying up to date with the child's evaluation. Let's see, Mr. Chairman. So once that evaluation occurs and a child is identified as potentially being eligible for special education and related services, the federal law and state law require schools to provide those services and according to a student's IEP, or an individualized education program. So this is, an IEP is a written document that includes has to include certain criteria and statements regarding the child, the goals, the extent to whether the child will participate in the general educational classroom or not, and when the services will be commenced. And this IEP document is developed by an IEP team, and this is an important requirement. This IEP team has to consist of, one, the parents of the child, at least one regular education teacher, if the child is participating in the regular education environment, at least one special education teacher, a representative of the school district who is involved in providing special education services for the child and educational services for the child, an individual who can interpret the instructional implications for the evaluation that was conducted on the child, and then any other individuals who have knowledge or special expertise regarding the child, and then also the child, if it's appropriate, to be part of the IEP team. So there's certain legal requirements that are established for developing this IEP. There's certain considerations that have to be given in the IEP team meetings, and essentially the IEP process has to ensure that the IEP is constructed in accordance with law and then periodically reviewed no less than once per year to address any lack of expected progress toward the child's annual goals that are outlined in the IEP. Mr. Chair and committee members, so there are, within this whole process of providing a free, appropriate public education in the least restrictive environment and developing and determining and evaluating children whether they need special education services and developing the IEPs, there's procedural safeguards throughout for parents and students with regard to this whole process. And these procedural safeguards provide avenues for a parent to to essentially have rights and within this whole process. So these procedural safeguards are things such as written notice requirements, parental consent requirements throughout the process, being able to access educational records, the opportunity to resolve and present complaints through the due process complaint process, and then the other state complaint procedures, and then mediation processes as well. And then let's see if there's other things I want to touch on here. So that's just a very, very high-level overview of IDEA. Mr. Chair and committee, the state law does also establish what I said as the Kansas Special Education for Exceptional Children Act. So this act generally follows the IDEA. It is set up to follow the safeguards and the processes that are outlined in the federal law. I will note on, and I'm going to skip through toward the end of this memo. There are some differences between the state law and the IDEA, and I'm going to highlight a few of the larger differences. So the first difference that you see in the first bullet point there is that gifted children, and you've all heard this, gifted children are included in the definition of an exceptional child under Kansas law, and they're eligible for special education and related services under the Kansas law. And so they would have an IEP developed for them, for the gifted, and go from there. Exceptional children under Kansas law who attend private school may have an IEP developed for them and have the provision of special education and related services provided for them if requested. Let's see, a few others. The main other one, I guess, special education due process hearing officers are required to be licensed attorneys. And then finally, another one that was recently passed by the legislature is that dyslexia under Kansas law is expressly defined as a qualifying disability under the law. Mr. Chairman, I'd be happy to answer any questions kind of on a general overview of special education law, or I can proceed just to get us into the special education funding discussion.
Does the committee have any pressing questions? Representative Johnson.
Thank you. Page 10 on private schools. If the school district makes a free, appropriate public education available to the child, and the parent places the child in a private school or facility, the school district is not required to pay for the cost of education of a child with a disability at such private school or facility.
Yes, so, yes, and I've got a memo on this that I presented to the 2023 Special Committee on Education that deals with the intersection of special education law and private school attendance. So in these scenarios, there's kind of three different scenarios that can occur. So the child can be placed in a private school by the school district as part of the IEP team meeting, as a means of providing that special education service. So that student would have an IEP, be receiving services under an IEP by the school district, even though they're placed in the private school. If the child is enrolled in a private school because the FAPE is at issue, free appropriate public education is at issue. In other words, the parent is having some difficulties with the school district in implementing the child's IEPs or the IEP, and has decided to remove the child from the school district and place that student in the private school because the FAPE is at issue. There's a little bit of a different consideration that would have to be taken into account, and that parent would need to then kind of work with most likely a legal advisor to start a complaint process or a due process complaint, and kind of use the legal process and the procedural safeguards of IDEA to deal with that. And then the school district may be on the hook ultimately through that complaint process to maybe possibly provide for that child's education at the private school. The third option that can happen in this case is if the child is just voluntarily enrolled in a private school by the child's parents, and I mean, it's just voluntary. There's still some child fine requirements that the school district has to meet, and they have to kind of work with the private schools within their area for these child fine requirements. But ultimately, if that child is enrolled in a private school and that parent doesn't consent to an IEP evaluation at the school district, there's no requirement for that student to receive special education and related services.
Thank you very much.
Representative Steele.
Thank you, Mr. Chair. You said the child find requirements, Nick. So if a parent places a kid in a private school and there is the child find and it's found that they have an exceptionality, is the school district then under that statute that you listed on page 15, that number 40, would that, then they would be responsible for implementing that IEP, and then that IEP, where those services are received, would be up to the district?
Yes, under an IEP situation, yes. If the student is going to be evaluated by the school district for special education and related services and develop an IEP, that IEP team via the school district and that team would determine where the services shall be provided.
So private school children are allowed to have IEPs in the private school?
Yes, but where those services are provided would be determined by the IEP team in that case.
Correct.
And I want to clarify that it's a little, with children, if they're voluntarily enrolled in private schools, federal law does require school districts to what they call spend a proportionate share of federal funds. Now, this is for federal funds, a proportionate share of federal funds to provide what they call equitable services to groups of children who are identified as having a disability. But that's not the same services that they would receive under an IEP. This would be under a services plan is what the law would call this. These students would receive services under the services plan, and a proportionate share of these federal monies would be expended for those services plans. There's some nuances there, for sure.
I have a question around, and it's kind of a part of the IEP process that I'm not as familiar as I would like, and I plan to do some more study on it. The expansion of behavioral issues into IEP. When did that, I know it might be a little off topic, but there was an expansion into that. When about did that happen? And maybe a separate follow-up for details that just for my own personal reading, but what can you tell me around that, the expansion? Because you listed some changes in these bullets. I don't necessarily see it in the changes, but maybe I'm missing it.
Well, so behavioral issues alone, unless it meets one of these criteria,
No.
it wouldn't qualify for, I mean, you have to meet one of these exceptionality criteria to first qualify. Now, certainly I could see behavioral issues maybe leading to some considerations of potentially needing to evaluate a child for one of these exceptionalities.
But I even wonder if the emotional disability, there could probably be some unhappiness, depression, a lot of times, development of physical symptoms or fears associated with personal, I don't know, I think sometimes those things would come with some behavioral issues. And was emotional disability always in the definition, or was that an add, a change? I don't know. I'm genuinely asking.
I believe. The term was emotional. Oh, that's right. We did. That's right, thank you. Yes, I mean, yes, so to my knowledge, it's always been there. I mean, we did, yes, as we had a bill recently to change it from emotional disturbance to emotional disability, but,
Yeah, I remember carrying that one.
I mean, a good lifeline here is KSDE and Burt Moore. I mean, he's your expert in with these types of issues and would be able to elaborate on that question in a lot more detail than I can, Mr. Chair, but I'm certainly happy to kind of look into it.
Appreciate it. Representative McDonald?
Thank you, Mr. Chair. I've always been a little curious about this other health impairment umbrella term, so much so that this year I submitted a bill that didn't get a hearing to consider adding fetal alcohol spectrum disorder into this category. And I think it would be really interesting to maybe hear from maybe one of the Department of Ed people as far as which things that are not listed. We have ADHD listed, ADD, Tourette's, epilepsy, diabetes. Are there other commonly experienced conditions that just generally put under other health impairment?
I believe so. I'll have to check and see what the regulations, because I believe the regulations, both KSDE regulations and federal regulations list out some of the other health impairment qualifiers, but I'd have to check and see what all. I think this memo, I think we captured it, but I want to make sure that. But I don't believe fetal alcohol spectrum disorder is specifically listed under that definition.
I'm just wondering if it might be worth us looking at to see if we've captured everything that day-to-day districts are. I just don't want a kid who's suffering from something that's interfering with their learning to not get their IEP because it's not listed on this chart. That's all.
Representative Brantley, did you have a question? I don't want to skip over you.
Thank you, Mr. Chair, and thank you for presenting this. On page 5, when it talks about the emotional disability, and I'm sure it's much deeper than this. So when determining a disability, that qualitative look to these bullets is kind of sparking a question in my mind rather than a quantitative. So based on these factors, when they diagnose these pieces, I mean, can you give us any more detail of, I mean, unhappiness, depression? I mean, what type of quantitative diagnosis are we using for that?
That's a great question, and I'd have to get back to you on that.
Okay. Thank you.
Just to kind of give you some more detail.
Well, let's remember, Nick is the expert on the law portion of it, not necessarily the process of diagnosing and some of those things. I mean, they're a good question, and maybe we'll be able to ask the department here in a little bit and just kind of some of their process on some of those as well.
Like I said, Burt Moore, and then there's other, I mean, there's other boots on the ground folks who do this on a daily basis, who know this stuff in and out.
Representative Owsley, did you have a question?
I did, Mr. Chair. Thank you. Nick, thank you for the overview. I didn't hear the up to 40% when we were talking about funding at the federal level of reimbursement. Is that in the memo? Did I miss that?
Well, I don't believe that's in the IDEA law. I think, I'll have to look. We did a little research in the past couple of years when we were kind of talking that issue. And I need to get on my computer because I think it was part of kind of the statement that was made by the federal government when they were initially passing it. And I can find.
I'd be curious. Seems relevant to the conversations we're having. And then I don't know if you have a memo up on Kansas senators' contributions to IDEA while we're looking at the history here. It's my understanding that Pat Roberts had something to do with one of these revisions, and I wouldn't mind learning a little bit more about that while we're jotting down memory lane. Thank you.
I do not have a memo on Pat Roberts.
You don't have a,
But I
you don't
can,
have a, you don't have a biography on Pat? Okay. Well, giving you a chance to pull it out of your back pocket, but there wasn't high hopes. But it's a good question.
There's not a history book over here.
I can't go to the books for that one. Yeah.
Well, I will let you jump to your next memo.
Okay, committee. So that was kind of the why. Why is special education is required pursuant to the law. So now this is the funding piece. So certainly there's federal funding that comes down, as Representative Owsley alluded to. There is federal dollars that are provided for special education, but then also state dollars. So for the funding portion of state dollars, there's a statute, 72-3422. This statute for the, and again, I'm going to reiterate, this is the funding portion, the funding side. This requires the State Board of Education to determine the amount of special education state aid that school districts shall receive for the next school year, the ensuing school year, based on the statewide excess costs calculation that's provided in the statute. So these excess costs, as you all know, are the costs that are above and beyond the provision of a regular education. So they're the costs above and beyond that to provide special education and related services. So the statute provides the calculation, and to calculate these statewide excess costs, the statute generally requires the State Board of Education to, you start off, you determine the total amount of expenditures for special education and related services. Then you subtract out the amount of regular education funding that's provided for students. And then you subtract out other dedicated sources of funding, such as Medicaid, federal funds, and other things of that nature. And that will get you, according to this formula, the excess cost, the costs above and beyond general education to provide special education services. So this statute then says, you determine the excess costs. It then says that subject to appropriations of the legislature, the total amount of special education state aid, the total for all school districts, is set to be 92% of the statewide excess costs. Again, this is subject to appropriation by the legislature, but the statute does provide that there is that 92% funding goal for the total amount of special education state aid. So the statutes do also provide that if that amount is insufficient to meet the special education state aid entitlement, the 92% entitlement, the amounts are then prorated amongst all school districts. So one other funding source, so that's just kind of general funding, and then, as I said, that's subject to appropriation. Then you all appropriate the amount of special education state aid to school districts each year. Another funding source that I want to mention is recently it was passed that school districts are required to transfer the amounts that they raise in their local option budgets that is attributable to their special education weighting to the school district special education fund. So all those funds that you appropriate for special education from the general fund go to school district special education funds, and then they're also required to transfer their LOB amount that's attributable to the weighting to their special education funds. That's the funding side. So now we've got, so for the state amount, we've got a whole bucket of money that needs to be distributed. So the distribution side. And Frank and KSD, or Dr. Harwood and KSD are going to talk about this here soon. So the distribution side, so pursuant to that same statute, of the total amount that's appropriated for special education state aid by you, the legislature, there is a formula in statute. And this formula states that currently, $528,018,516 shall be distributed pursuant to this statutory formula that's in KSA 723422C. This formula has been in place, I think, since 1974, if I believe, or if I can remember right. So this is the same formula that's been there for a little while. Now it's had a few little minor revisions through then. So how this works, and you can see in the memo, the first thing that's reimbursed, and these are kind of based on reimbursement to school districts. So the first thing that's reimbursed is catastrophic aid. Catastrophic is the high cost aid. This is provided as a reimbursement for high-cost students at a rate of 75% of the costs that exceed twice the amount of the prior year's special teacher entitlement. Then there's the Medicaid replacement aid statute. That's not to exceed $9 million to be distributed. And then there's the special education, transportation, and maintenance provisions. And these are reimbursed at 80% of actual travel and maintenance costs that are incurred pursuant to IEPs at school districts. And then lastly, one of the larger ways that it's distributed after all those prior distributions are made, it's the special teacher ratio reimbursement. And any remaining amount in special ed funding is distributed based on the school district's ratio of the amount of qualified full-time equivalent special education teachers and paraprofessionals compared to the total statewide amount. Now, I will note the law does provide that paras are reimbursed at a rate of 0.4 FTE, according to the law. So within that methodology, the teachers are counted as 1 FTE, full-time teachers counted as 1, and a para is counted as 0.4 FTE. So starting in this school year, fiscal year 2025, any amount beyond that $528 million has to be distributed pursuant to the Special Education Equalization Distribution Schedule that's established by the State Board of Education. So the statute required the State Board of Education to develop the Special Education Equalization Distribution Schedule, and the statute does state that the State Board shall give consideration to the discrepancies between each individual school district's excess costs as are determined pursuant to state law. And I will note that state law does have a statute that requires the department to determine each individual school district's amount of excess costs, and it's the same exact formula that's used for the statewide excess cost calculation. And so that's the distribution side. I do have something in this memo about the weighting, the special education weighting. Just get it in your mind, that weighting isn't actually a weighting that's applied to students like the at-risk weighting. This weighting it's only for LOB purposes. So when we talk the special education weighting, really what you're doing is you're determining the amount of special ed funding that you're providing in total. You're dividing it by your base aid amount, and you're getting a weighting amount that then is basically provided for LOB purposes. So that with LOB purposes, your total foundation, a school district's total foundation aid is then raised by that weighting, and they can levy a little bit more local option budget and raise a little bit more local funds through that mechanism. And Mr. Chair, members of the committee, it's quite a lot with special education law and funding, but I'd be happy to stand for questions.
Representative Johnson.
Thank you, Mr. Chair. Page 2 at top, it says, all special education state fund monies received by school districts must be deposited in each school district's special education fund. What about federal funds?
Those as well, yes. Those are deposited in.
The same fund?
Yes.
Okay, thank you.
Those funds have to be used for the provision of special education and related services. And the state law, in addition to requiring that monies go into that fund, state law also says that any funds you're spending for special education and related services as a school district have to be expended from that fund as well. So they funnel through that fund.
Representative McDonald.
When it comes to special ed transportation, that's a different bucket, or it's part of this bucket?
It's part of this distribution methodology. So those expenditures are all factored into the total expenditures for special education, and then the reimbursement is provided at 80% of transportation costs.
Follow-up question, if I can. So when we talk about the transportation buckets and that really confusing math from the Education Funding Task Force that I still don't understand, we exclude special ed transportation from that thinking? This is a revelation to me. Thank you.
Yeah, I believe so.
Seeing no other questions, I have one that might be a dangerous question, but it's one I think we hear a lot about. Basically being able to, the governor will say it, other people will say it around the State House, that we are constitutionally funding schools based on Gannon, based on the court ruling. Then we come to state statute of 92% for special education, and from that perspective, we are not. What supersedes the other? Which is true from a statute perspective, from the law?
Well, it's
And I'm putting you on the spot.
well, first off, you're in substantial compliance, and you were determined to be in substantial compliance according to the Gannon Supreme Court ruling, and now jurisdiction, they have dismissed jurisdiction of that case. So there's no longer any Supreme Court oversight. Maybe that's not the best term to use, but there's no longer the Supreme Court retaining that jurisdiction over the case. So the school finance formula is, according to the Supreme Court, you're cooking along with a constitutionally compliant school finance formula. Now, I will note, Mr. Chairman, during the Montoy litigation, first thing, Gannon didn't really, the plaintiffs didn't specifically argue special education very much, or that wasn't the biggest issue that they were pressing, it seemed like. And the Supreme Court only had a kind of one line in there where they said, and I'm trying to remember which opinion it was, where the plaintiffs kind of said, they said, well, special education's being underfunded. We're at 68% excess cost or whatever it was. And the Supreme Court had a line that said, well, that certainly, and they must have been arguing that with the structure component. They said that doesn't really apply to the structure component of the formula. Just because it's not meeting that 92% goal, that's not structurally unsound, but that does play into the adequacy, the total adequacy. And that was kind of the Supreme Court's mantra throughout the whole Gannon case, was to consider all funds, all funding sources, including special education. But they didn't focus on it. But during Montoy, there were specific arguments that special education was being underfunded. And the legislature and the court during those years were going back and forth, and that's how that 92% excess cost, first the statewide excess cost calculation got put into statute. It was during the Montoy litigation. And then how that 92% goal was also placed into statute. Because the legislature, and I don't know if I have my memo on that. I've got one. Okay. So, thank you, guys. I appreciate it. So, yeah, that's right. It was in that one. Huh? I've got another memo on that too. So during Montoy, the legislature kind of was going back and forth with the court, and at first they set it at 85% of excess costs, and then they had a stair step, kind of what the legislature did with the base aid. It started with 85%, we're going to fund 85% of excess costs, then 88% in school year 2006-07, and then 07-08, we're going to fund 91%. And then the court came and said, hey, that's still, and they said that's still unconstitutional, and not just for the special education reason, but other reasons too, but special education was part of it. And they mentioned the school districts having to transfer general operational funds to fund special education. And so this was a bigger part of Montoy. And then ultimately the legislature chose to bump it up to 92% excess costs and fund at that rate. And the court, and made other additions to the funding system as well. And the court said that the legislature was in substantial compliance. So just a little cautionary tale that Montoy focused on special education, and the plaintiff's arguments were pretty directed at special education during that litigation, whereas in Gannon it was more of a global funding argument, it seemed like.
Remind me what year Montoy was.
So those decisions, really 2004 through 2007, 6, 7. I don't know when the first district court opinion happened in there, but the Supreme Court cases were 04 to 06, 07.
And I mean that question in no way as a gotcha to anybody, because like we're all talking around those definitions, but they are related. They're separate, but they're in union all at the same time, and they get talked about that way. And I appreciate the clarity in answering the question. Other questions? Representative McDonald.
Do we know when we last got to 92%? I know we've talked about it, but it's not in my brain. 2011, thank you.
Yeah, we've got a chart to kind of show the excess cost percentages, or somebody does. I think KLRD or KSDE has a chart to kind of show those over the years.
Representative Steele, and then we may need to move on because we got a couple other presentations.
Thank you, Mr. Chair. As always, amazing, thank you. On page 2, the last paragraph, the third line, the equalization distribution established by the State Board of Education. But then it references a statute at the bottom. So is the statute saying that we said, hey, State Board, you need to do this, and then the State Board decided the equalization?
Correct.
So it's the State Board of Education that decided the formula for that, not the legislature?
Yes, as I said, the law says that the state board has to give consideration to the discrepancies between each individual school district's excess costs. But then the law requires the state board to establish that equalization distribution schedule based on those parameters. So those amounts above that $528 million, it's distributed to school districts based on that schedule. All that $528 million is distributed pursuant to the statutory.
Okay, thank you, Mr. Chair.
And with it, you didn't have any, sometimes I miss you. Didn't want to miss you. Okay. All right, with that, thank you very much, Mr. Meyer. I appreciate it. Great presentations. Now we will go to kind of moving from funding to then territory. I want to ask Matthew Willis to come up and walk us through a map of our state and what some of the construct looks like for our special education zones.
Thank you, Mr. Chair. Good afternoon, committee. So yeah, I'm just going to briefly touch on this big, colorful map you should all have copies of. If you've seen it before, I've had it for a few years. I apologize if any of this sounds similar. So just before KSDE dives into kind of discussing all the expenditures and the funding and everything, I just wanted to touch on how schools organize and administer these special education services. So there's 3 ways, and you will also have kind of a little front and back page kind of memo excerpt that covers these. So all of the school districts that you see in white in the map are districts that independently are providing these services. So the district is hiring the staff, providing the services, doing everything for its students on its own. I will also note on the back of the map, there is a list that kind of provides a legend for the names of the school districts and things of that nature. Additionally, if the school district does not want to provide all of that on its own, there are 2 kind of joint methods by which school districts band together to provide that. So any colored kind of area that has a 7 in front of it, 700, 723, et cetera, these are organizations that follow a cooperative model. So all of the school districts, they're part of that cooperative. One of them is the host district, who is the one who is hiring the staff, who is kind of overseeing and administering the provisions of those services, and the other members of the cooperative are then transferring or paying funds to the host district for the provision of those. And so you will have, for instance, an example of that being that the Harvey County Special Education Cooperative, there's 3 school districts, USD 460 Heston, 440 Halstead, and 373 Newton. Newton is the host district. They are in charge of running the cooperative and doing all of that work with it. The other 2 school districts might provide some services depending on what the agreements are, but by and large are going to provide funding to Newton, who is then doing that. All of the districts or all of the organizations that start with the 600 in front of it. So for example, in Southeast Kansas, we'll go to the A&W Cooperative, which is 603. That is an interlocal. And so what that is all of the member districts are banding together to create a third-party entity that is governed by a board of which each district has a member on. That interlocal agency is then the one that is hiring the staff, providing the services, providing those services for the member districts and everything within each district, providing them with transfers or payments of funds or things like that. So in all instances, students are obviously still getting the services, but when you get into looking at expenditures or funding or things of that nature, you will kind of see some differences. And again, each organization will be different as far as what they still might have local schools do on their own, other things of that. So I just wanted to kind of quickly go over that to help provide context of understanding in all of this discussion that it is not always the sake that a school district is receiving its money and directly providing its services. And with that, I'm happy to kind of stand for some questions or get out of the way and let KSDE jump in.
It's a great map. If you made it, great job. Any questions for Matthew? Just kind of gives you a good picture. That's why I'm eager to see those FTE org charts, because I like a good picture. They help me understand things. So thank you for this. I mean, I'm sure you can look right at your area and see, okay, we're an interlocal, we're a cooperative. You know, if you look out in western Kansas, Garden City is unique in their, I mean, they're an independent, 457, and Dodge is part of, I think they're an interlocal, because that makes it to where there's a whole different board to where each school district has one appointee onto the board or rep for the board, and so Dodge makes up, quite a bit of the services needed, but they have one vote on that board. So it can create some uniqueness and also some strains just based on the system. So just something for your gee whiz file. Thank you very much. Appreciate it. And now I think it's Dr. Harwood going to present to us, and I think you have a couple different handouts, whichever one he wants to start on.
So I'll
First.
start on the, thank you, Mr. Chair, start on the one that just says memo at the top, and it's going to go through that. So if you're looking at cooperatives and interlocals, I don't know why interlocals name themselves cooperatives, but most of the interlocals, the name of them is something cooperative. We didn't name them. I'm just going to say that. They made up their own names. So the memo that I have here is one that you saw earlier in the year. So it looks like this. And so Mr. Meyer did a great job on the appropriation side. But if you look at the bottom of the first page, that will just take you through the appropriations calculation for 2025. So the way it starts is that you start with the total expenditures. That is an estimate based on the previous year. And so that's $1.2 billion. And then you start subtracting the things out. So less the per pupil cost for regular education. So this includes some of the weighting. So it's the base and low and high enrollment. Doesn't include CTE, at risk, bilingual, and another one. But so some of the weightings are included and some aren't. So that was $186 million. The LOB attributed to special education state aid. This is not what he was talking about before. This is a calculation in that when you look at the part when you look at the $186 million, it would be what they get for only the students that have an FTE, okay? So the portion that Nick talked about, the required transfer, this is something different. This would be LOB that they get because of the special education students in their district, not because of their LOB in general. So when we look at the number there, it has to do with the actual FTE of special education students. And this is sometimes a difficult thing to talk about because we have about 90,000 students with IEPs across the state, but only about 29,000 FTE of special education students. And one of the reasons there's such a big discrepancy is that the most common IEP is for speech language. And a speech language student is just not most of their day is in regular education. So they're going to be a really small FTE versus a student that is in special education all the time would be a 1.0 FTE. So just making sure that that's a difference in that. That's the LOB attributed to the special education students being in the district, not the LOB that's attributed to the special education funding going into the general fund and adding to the LOB. Okay, so that's a hard one. Then the next part is federal fund, which is $128 million. For this year, we have in there $2.5 million in ARPA funds. That's not in there most times, but that was part of the calculation that went in there. So we kind of put it in and take it back out in some ways. Medicaid reimbursement, again, we'll talk about Medicaid replacement in a second. Medicaid reimbursement are payments that go from KDHE to school districts for Medicaid eligible services that they provide to a student with an IEP. So it's actually Medicaid funding that goes through KDHE. KSDE, we get the number from KDHE to put it in there. We don't actually do anything with those funds. And then state hospital reimbursement is an interesting one. It's been $300,000 forever. I don't know where it came from, but that's the number that's in there. It has to do with special education services provided by state hospitals to special education students. But it's just been an estimate as far as I know. And then you get the excess costs and you multiply that by 92%, which is $733 million. And then the appropriation was actually $601 million. So that's when we started talking about that it's 75% of the excess costs. So that's just kind of puts the numbers to what Nick explained a minute ago. So the second page is about the categorical aid distribution. So this is the part that's in 723422. This is the distribution model that's been there since 1974. It's changed a little bit, but basically what it does is it's called categorical aid because there are 4 categories. The first one we'll talk about is catastrophic aid. And again, this is some reimbursement. It's not reimbursement for all the expenses, but some reimbursement for students that are very expensive, have very high costs for special education services. And so a little bit to Representative Johnson's questions, there are times when a student is placed in a special program or even private school because of their IEP, and then the school district is responsible for those costs, and those can be literally hundreds of thousands of dollars, and that student would qualify for categorical aid, but it's only a reimbursement based on double the amount that the special teacher reimbursements we'll get to in a minute. Medicaid replacement is the next one, and this is not reimbursement. This is state aid. This is not Medicaid dollars. This is state general fund. But districts receive the funds through their special education funding based on the number of Medicaid eligible students that they have. This got put in at about 2008 because there was a change in the way Medicaid reimbursement was going to happen, and districts were going to lose quite a bit of funding. So the state said, okay, well, we're going to take a portion of our special education funding and then distribute it based on Medicaid eligibility. Not Medicaid services, just the number of students. It's set at $9 million. That's what it is. And so all we do is we get from KDHE how many Medicaid eligible students there are. We Take 9 million divided by that, and that's how we distribute the dollars for those students. So, all right. Transportation aid is the next one, as Representative McDonald talked about. This is for special education transportation. The only way you have an expense for special education transportation is if transportation is called for in the student's IEP. A special education student, like we'll go back to the student that might have a speech language IEP, that student doesn't need special transportation to get to school. So they just get on the bus and their transportation is in the general education fund. If you have a student that needs specialized transportation in order to get to school, it could be written into their IEP. This is a variety of things. It could be mobility. It could be behavior. It could be health. I mean, there are districts that have nurses on buses because that's what it requires for the student to be transported. Those costs get reimbursed at 80%. The other thing that's in there is the transportation of special education staff from one place to another. Because a lot of times what happens is a staff member may be in 4 or 5 different buildings, and so their transportation from site to site in service of an IEP can also get reimbursed at 80% for that transportation. So it's both student and staff transportation. Transportation, taking somebody to a specialized situation or a space outside of the district would fit in as special education transportation. Okay? So the way we start this, we take the $601 million, and actually it was $603 million because the ARPA funds went into categorical aid because the way the law was written, it was only the SGF difference that went into the other one, which we'll talk about in a minute. So that $2.5 million, and this is just important, I think, for everybody to understand, that $2.5 million is not carried over to 2026. So the $10 million SGF increase that's part of HB 2007 is a net increase of $7.5 million to special education funding. Okay? And I think that's been a lot of confusion, and I think that talking about the change from 25 to 26 is $10 million. There's a lot of conversation about, well, it's $80 million over 2 years, and I've had several questions today between legislators and school districts about, well, there's 80 million new dollars going to special education in 2026. That is not correct. For 25 to 26, it's 10 million SGF, a net of 7.5. Now, if you want to say you want to compare 24 to 26, that's a different number. I just think we have to be clear about if the increases and what the years are in that.
Representative McNorton, do you have a question?
Can you restate your philosophy or how, I'm getting confused on the ARPA money because you're saying that, go through that again.
Okay. So actually, if you go back to the first page, in the middle of the red, there's the less ARPA funding, $2.5 million. So that was money that was put in for this year. So we took it out of the calculation of excess cost because that was federal funding that was in there. But next year, so then there was a $601 million, the $601 million SGF. So the total that was available to districts was actually $603.5 million. If the legislature put no more SGF into special ed for 2026, it would be $601 million, which actually would be a $2.5 million cut in the amount of special education funding there. SGF would stay the same, but because they use federal dollars for supplement, that's not part of the 2026 budget, it's different. So what that means is that the $601 million, if you use House Bill 2007, would be $611 million, which is only $7.5 million more than the 613 that they, or the 603 that they had available this year. Did I make it more confusing?
And most of that is because the federal funds are a one-time pullout. You can't do that every year, so the maintenance of effort is different on those sort of funds. Go ahead, Representative McNorton.
Oh, I understand your thought process. I don't know if I agree with it.
Well, so I think it depends. If you talk about SGF or you talk about total dollars for special education, And so there's where the difference is.
So, yeah, but we did in 2000, House Bill 2007, increase that by 10 million,
SGF.
not the 7.5 that you're actually saying we did.
So, no, so
So we actually gave 10 million additional dollars, not what we wanted, but that's what's in the bill. It's not 7.5.
so it is $10 million in SGF. That is there, and that is correct.
Yes.
Because the federal dollars that were appropriated by the legislature last year don't continue, the net available to districts is 7.5. But no, I have no argument that, yes, the 2007 talks about an SGF appropriation of $10 million. That's,
Okay.
yeah.
I understand. Thank you.
I even almost didn't bring that up. The confusing part is when people talk about that it's over 3 years we've done this amount, and then it comes across as, well, that's what we're doing this year, and that's the problem that's not there. Because when you look at 2027, when you look at the budget, it looks like there's $10 million in 2027. It's not 10 million new dollars. There would be no increase for 2027. It's in there, but yes. Okay.
It would just be maintenance of effort. Yep.
And the other thing is that federal funds don't count against maintenance of fiscal support, so that's why they don't have to be maintained.
I also don't disagree with you that 10 million minus 2.5 is 7.5. That's pretty, I mean, that is the math. I mean, okay.
But I think that's why we have to be clear of what we're talking about. If we're talking about SGF, then it's $10 million. If we're talking about the total appropriation for special education, the change from 25 to 26, it's $7.5 million. So,
Representative Brantley.
So I'm a little confused. So last year, they're given 80 million, correct? 82.5, 2.5 was from the ARPA.
so there was $73 million in new appropriation from SGF, and then $2.5 million of federal funds, which is $75 million. Now, the question would be, is there was already $7.5 million that was supposed to be appropriated as an increase. That's the part where it gets confusing about which year it was appropriated from and when it was actually an increase and when it was not actually when it was just same dollars next year.
So the question is whether it was appropriated last year or the year before, because whatever was given last year has to be given this year, correct?
So to maintain fiscal support, yes.
And then the 10 million that from here is an enhancement on top of that.
For the SGF, that is.
So the funding that we give in this committee is an enhancement on top of the 4.3 budget increase overall, which includes the 80%. Am I wrong?
I didn't follow the 4.3. I don't know where that came from.
4.3% increase over the whole budget.
So the 4.3% increase applied only to the consensus estimate, which is the base increase. And so this would be above a separate amount to that. And so this committee did $30 million and then appropriations put it down to $10 million.
That's an enhancement. That is not, okay, so that's an enhancement up and over what we had.
Yes.
Okay, thank you.
Representative McNorton.
So maybe to try to clear up, last year, the 72 that we gave was an enhancement. So just so you can compare. So
Representative Brantley.
So last year's 72 then continues this year, or is it 80?
So the 72 continued with 10 million more. And actually 73.
80
So yes, it would be 83.
million.
Yeah.
And so special ed is being funded 83 million.
Over 2024, not over 2025.
Okay.
Yeah. And that's the part that I think is important is if you're talking about how much got added, it's important to know what did you start from? And so for 25 to 26, it would be an increase of $10 million of FGF. Based on 2007, from 26 to 27, there is no increase. That's typical. That's the way they've always done it. You've appropriated the dollars that would be made of effort, and then you talk about any additions the next year. That's not, I mean, so that's not anything different. It's just that some people will talk about, well, we're adding $20 million. Well, it's $10 million one year and then the same $10 million the next year.
And I think the valid number on the front page is that bottom number. I mean, it's 601. I mean, if we'd get better about saying, this is how much for this year was funded to special ed with all the subtractions, this is what counts towards the percentage. Representative McNorton.
So go back to that front page, Dr. Harwood. Down at the bottom, we had excess cost would have been $733 million if we funded the 92%.
Yes,
We funded 601.
that is correct.
That's about 82%.
I
Instead of
believe,
70, whatever, if you do the math on it.
so the excess costs are actually 796 million. The 733 is
that's where-
92% of that.
Gotcha. Okay, thank you. I'm sorry.
I can say, well, this is an Excel formula. I think that usually we can do that math. Yeah. Yeah, so the excess costs are actually 796. Yeah. Yeah. So I got us off on a tangent a little bit, but the point I was trying to get to is that the last one we're talking about is special teacher reimbursement. And so when you talk to your constituents in school districts, they're going to talk about this one as categorical aid. All four are categories that are categorical aid, but what they're talking about usually when they say categorical aid is special teacher reimbursement. The important part about this that's going to come up is that last year, the reimbursement per FTE was about $31,000, a little over $31,000 per FTE, and then paras would have been 0.4 of that. This year, it's probably going to be closer to $30,500. The reason for that is the amount of money is the same, and transportation costs went up, and catastrophic aid costs go up, and so that leaves less money for special teacher reimbursement, or what they call categorical aid. You're going to hear about that. Now, the $73 million that we're going to talk about in a minute came through a different formula. So that should have more than made up for that difference, but you may hear that, well, we're getting less per teacher. That is correct. But you got this other pot of money over here. So ordinarily, it all would have stayed in the same amount, so you might have seen an increase in categorical aid. That didn't happen. So I just wanted, I mean, we try to educate school districts on making sure they're using the right words too, is that we expect special teacher reimbursement to go down. We actually expect it to go down even more next year because we don't have that other $2.5 million that's in there. And so that's just going to be a function of the way we're doing things. What they want to look at is add that with the local contribution state aid, which I'm going to talk about now, because that's where the new money is coming from. The other money's going down because transportation costs go up. It's about 7% a year is what transportation costs go up. All right.
I just want to note for everybody, I mean, look at that number as far as on the bullet point under special teacher categorical aid, 432 million is, that's the biggest,
Oh, yeah.
that's the biggest chunk. Just so you know, because that's what's funding the FTEs that are serving the students, and that's our funding model currently. It's a FTEs of service towards the students who need it. So just another note from helping this make sense.
That's where it says there, the reimbursement was $31,670 for 2024. It's going to be about $30,500 for 2025. So when people tell you that, you cut funding because that went down. No, the funding just coming through a different stream, and I'm going to explain that stream to you now. Okay? Any other questions? It's about what would be 72, 34, 22, which was, we'll call the existing law, and then we'll move on to what happened for this year. Okay. All right, so if you look at the second sheet, This is what the state board approved in June as a way to distribute the $73 million. So one of the things I'll say before is that, as Nick pointed out, one of the things that the state board had to consider was district-level excess costs. And they considered it, and we considered it to be disequalizing, so we did not use it. And the reason we think it's disequalizing is there are so many parts to that make districts so different. One of them would be the low and high enrollment weighting impacts districts so differently on how you do that cost. And that's money that's supposed to be making up for the lack of economy of scale in small districts. So if you're going to count that against them in this, you're going to penalize them. The other thing would be is what portion of their categorical aid is transportation, because a rural district's going to have more of that. And so it was just making we thought that it was actually being disequalizing, so we came up with a different way to do it. The way we did it was actually what was explained to Senate Education last year and was talked about extensively during the conference committee that went on. And so what we talk about it as being is a local contribution model. So what we came up with is a way to determine what each district was spending from local funds towards special education costs, because what came out of the law, it was that we want this $73 million to offset what districts are spending on local funds towards special education. But we don't want to do it with the old model because we don't think that's fair. So we decided, well, if we were trying to change that amount, let's use that number to do that. And so what we did is we started off with the total expenditures from the district. And this goes back to Representative Johnson's questions about the special education fund. By state law, if you don't spend it out of the special education fund, it doesn't count as a special education expense. So districts could hurt themselves by paying special education expenses not out of that fund. We tried to we gave them lots of warning. The other thing about that is like, well, why don't you just move a whole bunch of stuff in there instead? Well, the same state law says that if it's not in service of an IEP, you can't pay it out of the special education fund. So we thought, okay, let's start with that. And then we'll subtract out all the money you get. So that's the state aid that you got, the federal aid that you got, the Medicaid reimbursement that you got, and everything else was a local source. We don't know if it was general fund or supplemental general fund LOB or a bake sale. We have no idea how they paid for it, but we knew they had to pay for it. So at the end, what we did is you add up all of what everybody paid locally, find out each district's share of that, and multiply it by $73 million, and that's what that district would get. So if you turn to the first page of the spreadsheet, and I waited on that because people will start looking at their own districts. If you look at the top in the dark purple, one of the things you'll notice is that there's a row for interlocal and cooperative. So if the expense was at the interlocal or the cooperative level, we didn't count it because that was not a school district expense. That was a cooperative or interlocal expense. So, and that's because sometimes they have expenses that they could be from other ways, but that's how it was reported. So then if you look at the local effort, there was $439 million in local funding that went towards that $1 billion, or a little over $1 billion in expenses. So if in the case of Erie Galesburg, they had $324,000 in local expenses. So you take 324,000 divided by 439 million, and then multiply that by 73 million, and they end up with $53,934 out of the 73 million. So this is where if Erie Galesburg came to you and said, you know, we're getting $1,000 less per teacher, you say, well, how does that compare to the $53,000 that you got through this other formula? Some districts, you'll notice if you look at the percentage, there's a wide range of what those percentages are of what is the local contribution. So you can look at your own districts and look at what percentage is that. Now, so a lot of things would go into that. Teacher salaries would be a big part of that Because remember, you're getting reimbursed last year for 31,000, even if you paid the teacher 75,000, or if you paid the teacher 32,000. Now, that was not a full-time teacher at any district that I know of, but you kind of get the point, is how much you're spending mostly is determined by how much you're paying staff.
I guess one of the main underlying questions for me is, and everybody's welcome to ask some, of course, the idea of creating greater equity or parity between districts. You say, I'll study this and kind of look, but do you think it helped do that?
So I have asked that question.
It's kind of an opinion question, but it's
I
what
think
the purpose of it was.
Given the time that we had and the direction we were given, I believe it was the best solution we could come up with at the time. I will say before the state board voted, I asked superintendents and special education directors and business finance directors in a lot of different situations. I said, tell me where this is wrong so I can fix it before they vote on it. And I got very little input. I've asked since that time, again, saying, now that you actually got the check on January 15th, tell me why you think it was unfair. And nobody no district has said, I think we did this wrong, you should look at something else. I'm not going to say that it's the only way to do it, but I will say that districts understand it and they are accepting of it as it did look at, well, we got the money based on what we had to spend locally, and that makes sense to us if the goal is to minimize or to decrease that local reliance.
And the other thing would be, remind me of the theory around, I'm almost, in my mind, I'm thinking of the first category of aid as almost a base special ed aid, and this being kind of the supplemental. It's just how my mind is working that way. Is that, I was explaining myself and I kind of forgot my question. Yeah, I forgot my question.
So I think I can try to answer your question based on where I think you were going with it.
Yeah.
What this did do, if you look at the percentage of special education expenditures that were local responsibility, this would decrease that number.
My question, now that I remember it, my brain's back on my head. The idea of where we might get out of ratio to where this could be helpful to an extent, but then also harmful. It's almost like if the supplemental was larger than the base, it could cause problems. Maybe talk around that hypothetical. We're not there yet, but that hypothetical situation.
And actually, that's one of the things I told the state board and I have told districts across the board is that if the supplemental gets, I don't know, half of the base, I think that's going in the wrong direction, and you would probably want to do something with the base. And I think what I've said so far is I think if you look at the Education Funding Task Force, which is one of their roles is to take this on, I think we're fine until 2027. But I think at that point, the legislature needs to decide if this works or not. And the idea of a multi-tier system, I think you'll find out it is not uncommon. And it's special education, a little bit like at-risk, is difficult to fund because it's just so different. I mean, the difference in cost between a student that goes to speech therapy for 30 minutes twice a week versus somebody that has significant medical needs and is tube fed and has a one-to-one nurse, it's just difficult to compare that. Now, Kelly was probably going to talk about this, but some states actually say, based on those exceptionalities that Nick talked about, this is the weighting for this, and this is the weighting for this, and this is the weighting for this. I'm going to tell you that even in those weightings, they're not the same. You might be able to come up with a way to do it that kind of averages out where, okay, this one didn't cost as much, but this one cost more, so it's there. But that might be more complicated than what we have.
Representative McNorton.
Thank you, Mr. Chair. So this seemed to work for you. So going forward, just explain to me, so we had 73 million, we put 10 million more in it.
Yep.
So is that going to be based on 83 next year? Even though that 73 is quote in the budget now, so this distribution will be 83.
So because the current law says that we start with 528, and anything above 528 goes into this. So that would be 83. So what we will do is we will use 24, 25 actuals for expenses and resources and recalculate this.
Whatever that comes.
Yeah, the 528 is an important number, you know, to remember. Anything above that is in this other, yeah. Representative Steele.
Thank you, Mr. Chair. You may be able to answer this, or Nick may need to be able to answer this. The KSA 723422, on this page 3 of Dr. Harwood's document, the reluctance to distribute additional sped funding using the and then we talk about this House Sub Bill SB 387. So which is the law now? And did one law not get used because we had the House Sub Bill last year, or?
So House Sub for Senate Bill 387 amended 723422.
Okay.
So this, I mean, this process that Nick described is actually in there now.
Thank you for the clarification. Thank you, Mr. Chair.
Representative Bowsley.
Thank you, Mr. Chair. And Dr. Harwood, is it safe to assume that if the $10 million sticks as the enhancement for this year, that we're safe with this formula till 2028 at least?
I think this formula is going to do what what the legislature talked about it doing. My concern would be is if you do this for 20 years and now all of a sudden the supplement is, you know, $300 million versus 528, I think at that point, if the supplement is a major portion of the base, I think you got to rethink that. But this should be fine until then, yes.
But with the 73 million enhancement the year before, that we were looking at that as a forecast for a 4-year plan of 73 million year over year over year enhancement, you know, building that base. And if we're moving at the 10 million enhancement, we're at a snail's pace compared to what was forecasted.
That actually would have been part of my comments before, because if you looked at so you had, you know, 25, 26, 27, so you had $210 million if you would have gone at $70 million a year. 210 as a portion of 528, I think is a bigger deal than if you do 10 million over that time. Now you're looking at $100 million at the most.
And I would say, not only did it appear from your perspective to not draw any complaints from school districts, I honestly haven't heard any legislators complain about it neither. So I'll give us a A for creativity on that one.
I will say that this is the first time I've explained it to the legislature since it was passed by the state board in June.
Other questions? There's a lot of things I don't understand in the State House, but I actually understood it. So I didn't, there was something there to it. And honestly, I think you were a big part of the idea during conference committee. So there was some team effort around, and looking back and feeling pretty blessed around the last year's appropriation. So it was good stuff that we did in both policy and funding, so.
If I may, to answer Representative McNorton's question that he didn't say loud enough for everybody to hear. The $210 million, I was looking at it as 3 years until 2027, when the idea was to redo everything. If they would have done a 4-year program, it would have been $280 million. But the conversation last year around this was, we're going to do this until we until we look at everything again, and we'll see. So it felt like this was more of a temporary thing. That's why I kind of looked at it that way. We were already not agreeing on how to do math, so I didn't want to.
Well, we were not as speedy as House Education Policy Committee, but we had some great questions and some great information. Thank you, Nick. Thank you, Matthew. And thank you, Dr. Harwood. And thank you, committee. And we will see you Monday, and have a good weekend. We are adjourned.